So, to help you do well, I will introduce you to the key features of rights broadcasting organizations via a model of 5W and 1H.
It sounds strange to me. What are they?
There are 6 questions you need to answer in order to master the copyrights of broadcasting organizations. You can take note to keep track better, and the first question starts with why.
Why? Why do we need copyright for broadcaster or society as a whole?
Oh yeah, you're right. Can you answer that?
Okay, let me try. Copyright is intended to guarantee an economic reward or encourage media content authors to be creative and innovative. Creativity and innovation are considered to be the heart of a successful broadcasting industry. From the social perspective, broadcasters' activities are key drivers of social cohesion, cultural development, and freedom of speech. Copyright matters for not only broadcasters to help them achieve profits and success, but also contribute to the development of society.
And the next W is who is protected, and of course, the broadcasting organizations.
I see.
Although there is no definition in Rome Convention of broadcasting organization, it has been generally accepted that these are entities which provide broadcasting services to general public over wireless waves. They take financial and editorial responsibility for selection, arrangement, and investment of transmitted content.
Let me guess. The two other W is where and when, which means since when we have the protection of broadcasting organizations and other literary and artistic works came into force, and in which countries have the rights of broadcasters been protected.
Good job! I think you're about to get all the points.
As far as I know, the international framework of broadcasters' rights that our country has supplied includes 2 main conventions and 1 agreement. The first convention is the Berne Convention for Protection of Literary and Artistic Works, signed in 1996, came into force in 1997. Later, the Rome Convention, administered by the World Intellectual Property Organization, was established in 1961 and came into force in 1964. By now, 92 countries have adhered to the convention. The latest regulation of the TRIPS or TRIPS agreement, established in 1994 at Uruguay round of the General Agreement on Tariffs and Trade, came into effect in 1995. Since it binds 164 countries that participate in the WTO, TRIPS has impacts on the wide-ranging geographical scope. However, regarding broadcasters' rights, TRIPS does not provide a higher level of protection than the Rome Convention. Vietnam also has its own intellectual property right, introduced in 2005. It was quite long, but I hope that I didn't get it wrong.
Perfect! And the last W is what is protected under the rights of broadcasting organizations. There are 5 objects in total. And as a media manager to be, could you list them?
Sure, I've read about this before. The first one is traditional transmission over the air for direct reception by the general public. The second one is cable-originated transmissions of program-carrying signals. The third one is rebroadcast signals. We normally broadcast to the public after some editing of the content, for example, through the addition of spoken comments or advertisements. The next one is simultaneous, real-time streaming of the first and the second ones. Such streaming refers to cases where a broadcaster or cable operator engages in a simultaneous streaming of the same content. And the last one is...
It is internet-originated real-time streaming, and the content here is transmitted on the internet only. It can be perceived only at the time when it is transmitted.
So, I still get 4 of them.
Yeah, you know the objects very well. I'm surprised. And of course, the only H in the model is how are these rights of broadcasting organizations applied?
This seems difficult to me. Could you help me with this part?
Sure. According to the Rome Convention for the Protection of Performers and Producers of Phonograms and Broadcasting Organizations, Broadcasting organizations have the right to authorize or prohibit certain acts, and the first action is rebroadcasting of their broadcast. So the word rebroadcasting is simultaneous broadcasting by one broadcasting organization of the broadcast of another broadcasting organization, and limited to over-air transmissions, excluding the deferred rebroadcasting at a later time than the original broadcast. Broadcasting organizations shall enjoy the right to authorize or prohibit the rebroadcasting of their broadcast. Can you give me an example?
For example, VTV, the national television broadcasters of Vietnam, announces its broadcasting rights for UEFA Euro 2020. Is that correct?
Exactly. So from now on, I'll give you the information and then you find out an example. Is that okay?
Deal.
The second is the fixation of their broadcast. It is one of the core rights of broadcasting organizations, or a restricted act under the new international instrument. The Article 30b of the Rome Convention grants broadcasting organizations the exclusive right to authorize or prohibit the fixation of their broadcast. A fixation is defined as an embodiment of sounds, or of the representations thereof, from which they can be perceived, reproduced, or communicated through a device.
Examples of such embodiments are tapes, compact discs, as well as the memory of computer.
Very good. And third one is the reproduction of such fixations. Reproduction of broadcast is defined as making a copy or copies of a fixation. According to the Article 3e, the right is qualified into two respects. First, it applies to the reproduction of fixations made without the consent of broadcasting organizations. And second, it applies to the reproduction of fixation made without the authorization if they are made under the limitations or expectations allowed under the convention.
For example, the illegal copied version of Paris by Night shows, which are sold in Vietnamese local DVD shops for lower and attractive prices ranging from 40,000 to 50,000 Vietnam dong. This is considered as violating the reproduction rights of broadcasting organizations, in this case, Thuy Center.
You're going to master this, Joey? And the last one is the communication to public of their television broadcast. If such communication is made in places accessible to public against a payment of an entrance fee, the Article 30d grants an exclusive right of communication to public of television broadcast if that is done in places accessible to public on a payment of an entry fee. However, no communication to public for payment occurs within this sense when the communication takes place for commercial purposes, if it is only as an accessory service. The Article 30d leaves it into the national law to determine the conditions under which the right may be exercised, and the Article 61b allows the country to declare that they will not apply the rights.
For example, some cinemas, cafes, and hotels, in order to attract clients, showed television broadcasts against separate payments for their own gain, which violated the right of communication to the public.
You're such a good learner. Well, you can see that the broadcasting organizations have been granted the rights to protect their property, and especially the exclusive rights for 20 years under Rome Convention. However, there are several threats in broadcasting industry, especially the unauthorized rebroadcast online through live streaming on computer and mobile devices, or the unauthorized recordings of broadcast on videotapes, DVDs, or USB drives. For example, the live stream of sport events is the farthest growing segment of broadcast copyright infringement. During the 2014 World Cup, some 3,200 World Cup live stream takedown notices were issued by Violas on the behalf of FIFA.
Oh, really? I think the related rights in the Rome Convention can cover nearly all aspects of this industry, but I don't even imagine these risks in terms of organizers.
They always exist, since the perfect digital copies of television programs could be made and transmitted with a few clicks. You know, the world is changing every day, and the convergence of info communication technologies and the emergence of new digital environment enlarge the gap between law's protection scope and technology reality, resulting in the loss of broadcasting rights income with knock-off effects on job, content creation, and community funding.
Oh my god, I didn't realize that you have such deep knowledge in the field of IP. Now I have understood everything and feel extremely confident. Thank you so much.
No problem. I have a chance to research this while participating in the IP course at the university, and I hope that the provided information will help you to perform well tomorrow. Good luck!
Bye, see you around.
Okay, bye.